Vogtle guards push for union decertification. Vote a labor dispute is unfolding at Plant Vogtle, one of the country's largest nuclear facilities, as security guards take formal steps to reconsider their union representation. A group of the plant's roughly 250 guards recently submitted a petition to the National Labor Relations Board, NLRB, requesting a decertification election that would determine whether they continued to be represented by the Security, Police, and Fire Professionals of America, SPFPA. The NLRB requires such a petition to meet a certain threshold of employee support before moving forward. Records confirm that the Vogtle Group has met that bar, initiating the process for a possible employee vote. If held, the election would allow workers to directly decide whether the union remains their exclusive bargaining representative. The petition effort is being supported legally by the National Right to Work Foundation, an organization that frequently backs employees looking to challenge union representation. While the filing doesn't itself determine the result, it reflects a significant level of dissatisfaction among at least part of the workforce. Right-to-work law shapes the stakes. Georgia's status as a right-to-work state plays a notable role in this development. While workers cannot be required to pay union dues under state law, federal rules still allow certified unions to act as exclusive bargaining representatives, meaning they negotiate for all employees, dues paying or not. For the guards at Plant Vogtle, the issue isn't about dues collection, but about who has the authority to represent them at the negotiating table. If the decertification effort is successful, the union would lose that exclusive status, and employees could either represent themselves or consider alternative structures. The debate reflects deeper questions about how well centralized unions like the SPFPA can represent a workforce with local concerns, especially in specialized, high-risk environments like nuclear security. Supporters of the petition argue that collective bargaining through SPFPA no longer reflects the interests of a meaningful portion of the staff. Meanwhile, union advocates continue to highlight the role of unified representation in securing consistent terms of employment, particularly in complex or hazardous workplaces. Broader labor dynamics in security. The Vogtle case isn't isolated. Similar tensions have surfaced in other states where SPFPA represents security professionals. In some cases, employees have raised concerns about how contracts were negotiated and whether dues were properly managed when workers opted out of membership. Critics argue these examples highlight structural issues in how national unions interact with decentralized security workforces. The outcome at Vogtle, now pending NLRB review, could send signals to other facilities facing similar internal debates over labor representation. For employers, HR leaders, and labor attorneys, the Vogtle situation is a timely case study in how employee sentiment, labor law, and union authority intersect, especially in right-to-work jurisdictions. As the vote process advances, stakeholders across the industry will be watching closely.